the judicial process. Today we're discussing the second part of our judge lecture, and specifically we're going to take just a brief look at state judges and how state judges become state judges. So when we think about the selection of state judges, there are four general methods of judicial selection, with some states adopting more than one approach. This includes appointments, partisan elections, nonpartisan elections, and merit selection plans. Let's take a look at each of these in turn. So when we talk about appointments, when we think about appointments of judges, right? This might be an appointment by the governor, by a legislature, maybe relegated to senior judges. It really is, it depends. But if we look at the historical system, 8 of the original 13 states relegated judicial appointments to state legislatures, right? So the state legislature got to vote on who became a judge and who didn't. The governor wasn't really involved. And the other 5 of the 13 states, so all 13 were appointment-based, the other 5 permitted the governor to make an appointment subject to an up or down vote by the state legislature. So in these 5 states, they really resemble how the federal Article 3 courts work today, how the federal district courts, how the federal appeals courts, and how the U.S. Supreme Court all works. Instead of governors getting the appointment, it's the president, and then it's the Senate that gets the up or down vote. Again, in the original 5 of the original 13 colonies, the governor got the appointment, and then it was an up or down vote by the state legislature. Now, over time, the appointment-based system, right, whether it was via state legislatures or whether it was a gubernatorial appointment, largely lost favor because of the perception that appointed judges were, quote, beholden to the politicians who appointed them to the bench. Right, so the rationale was, well, if politicians are the one making the appointment, then they are going to be the ones, if you want to stay in their good graces, you're going to make rules and follow rulings and uphold laws that they pass so that they keep you on the bench. Right, so as a result, today, less than 5 states use a pure appointment-based system. Right, so most of the other states, the other 45, do not use appointment-based systems, or at least not in the purest sense. So then we have the next type of a way judges are selected, and that's elections, right? So more than half of the states involved in an electoral process at some point in the selection of state-level judges. And usually this is at the trial court. Now, there are 2 ways that a judge can be appointed, or excuse me, elected. States will either use a partisan election system or a nonpartisan election system. So if we look at partisan elections, right? Partisan just means you declare a political party, right? So you declare if you're a Republican, a Democrat, Green Party, whatever. And you run based upon that platform. So partisan elections were really common among the states after Mississippi became the first state to use partisan elections to choose judges in the 1830s. That being said, that only lasted for roughly 70, 80, 100 years, because at the turn of the 20th century, partisan elections really began to fall out of favor. And there was 2 thought processes behind this. Right? The first is that the law is the law, it knows no party. And the second is that political parties are inherently corrupt. Right now, this is, again, public perception, but there's also a bit of truth to it as well. Right? So when we think about the law is the law, it knows no party. So what does it matter if the person on the bench is a Democrat or a Republican if they are finding somebody guilty or they're trying to see if somebody's guilty of armed robbery, right? An armed robbery is an armed robbery. A violation of the law is a violation of the law. Why do we need to incorporate politics into this process, right? Why do we need to incorporate political parties? Now, there is the thought process, right, that this might become important when it comes to challenging certain laws. So if you go before a judge that was appointed by a Democrat or a liberal, they are probably going to put a stop to or put an injunction on a federal law, or excuse me, a state law that was rendered by maybe a state legislature that's conservative, and vice versa, right? If you go from a conservative judge, you're probably trying to challenge a more liberal law. So the law does have a little bit of politics behind it, right? And the second part is really interesting one, is because political parties are inherently corrupt. Now, this is mean in a way and not mean in a way, and I'll discuss what I mean. So it's mean in the way that basically they say political parties, they work kind of as a machine, right? So not everybody in a political party has the same access. Not everybody in the political party gets the same chance, right, that others do. And it's largely controlled by the leadership of the political party. So if you recall from the primaries when Hillary Clinton was ultimately the nominee for the Democratic Party, there were problems with the Democratic Party taking away votes from Bernie Sanders, right? Because they wanted Hillary Clinton to be their nominee, not Bernie Sanders. They thought they had a better chance with Hillary Clinton than they did with Bernie Sanders. So they manipulated the process. Now, that being said, it wasn't so bad that it changed the outcome of who the ultimate primary, who the ultimate nominee was, but it could have, had it not been called out and checked. So again, political parties, they're inherently corrupt in that regard, right? It's at least in the Democratic system, and the Democrats, it's a turn-based system. So you earn your way up through the ranks, and then once your turn, you get to run. They don't necessarily do it based upon what's best for the country or what's best for what's going to be the most likely to win. It's kind of a turn-based system. Well, the same is true for the Republican Party, right? The Republican Party, they don't necessarily use a turn-based system. They use and they don't even necessarily use a what's best for the country system. They use a what's going to get us the win system, right? What's our best chance to win? So both parties are inherently corrupt, and neither, you could make the argument, has the best interests of the United States at heart at the political party level. Maybe candidates do, but not necessarily the political parties. So because they're inherently corrupt, and because the law should not differ from Republican judge to Democrat judge in terms of, is somebody guilty of armed robbery, partisan elections really began to fall out of favor. As a result, today, 14 states employ nonpartisan elections, in which the candidates not only do not declare a political party, but they are prohibited from declaring a political party. Right? So if it's a state that employs elections but says it's nonpartisan, if you see their signs, it might say elect so-and-so for county judge. Nowhere on it will it say Republican, Democrat. Nowhere will it have the little donkey symbol. Nowhere will it have the little elephant symbol. That is actually against the law. It's against the rules. You can be fined and a lot of things like that. Now, that being said, generally speaking, people know, especially at the state level, where other people stand politically. Right. So keep in mind, a lot of these state elections occur for like county judges. Well, counties in small states, basically everybody's political affiliation. Right? If they've been involved in politics, their affiliation. So they're not prohibited from discussing politics and indicating that they have a leaning one way or another. They just can't officially declare a political party. So even in these states, we do see political parties coming into play. It's interesting is when we look at the electoral system, some states still use straight ticket voting. What straight ticket voting allows you to do is it'll have all the candidates listed, right, just like you would in a normal voting. But across the top, there's a selection and it says select all Democrats or select all Republicans or select all Green Party, whatever. And all you have to do if you want to vote for just one party is just fill in that one bubble and you have voted for everybody underneath it. It's a straight ticket. That's a problem in and of itself. I believe that you should vote for the individual person, not necessarily the party, in terms of what you think is best for the country, what they bring to the table, etc. Right. So, for instance, I voted for candidates from both major parties before, and I think that's really the way it should be. But that's even true in partisan states where they use straight ticket voting. So if you are a Republican judge and this last election, right, Donald Trump was the nominee for the president, you in some states you could use straight ticket voting in which you just selected Republican. And so you might have been voting for Donald Trump or you might have been voting for that county judge, but really what you did is you just voted for everybody from that party. Now, some people say it saves time, and obviously our polling system is a little bit slow and antiquated, but there's obviously problems with that. Now, that being said, they don't have that necessarily when it comes to nonpartisan elections. But generally speaking, by the time you get to the election, you're going to know how somebody leans one way or another politically. And you would be surprised at the number of people who just see a party and they don't care about anything else. They don't dig deeper. They don't ask questions. Right? So I remember when I was in high school, after my mom passed away, I won't say which party, but one of the parties encouraged my father to run for state legislature. Right? And he got the nomination from the major party to run for the state legislature. And we would go campaigning and we'd go to people's houses, knock on the door to introduce ourselves. And a lot of times, you'd be surprised how many times this occurred. Somebody would scream, "I know who you are," and they slam the door. Or other times they'll say, "What party are you?" And you'll say, "Well, technically I'm from this party, but here's what I believe." And before you say, "Ian, here's what I believe," that door would slam in your face, right? So people really do become beholden to political parties in a way that something that even George Washington warned against, right? George Washington was not a big fan of political parties, warned against the danger of them. So to know that there's still a lot of states that use electoral systems that are partisan is problematic. But again, it's even true in nonpartisan systems, right? Because you will generally know somebody's affiliation. Now, that being said, this is really important because once a judge is selected, right? So once there's a vacancy and a judge is elected, the chances of them being voted out of office are very, very small. They are minuscule. Right? We generally keep judges in office because, they're already there. They know what they're doing. I think they're doing a good job, even if you have no clue what they're doing. It's one of those kind of fluke things. It's one of those positions that a lot of people don't care about necessarily when they think about politics. And so they just kind of keep electing the same person, especially if that person is from their party. Now, that being said, when I say that they are generally kept in office, think about it this way. There are very few sitting judges who ever run opposed for re-election, right? In fact, one study found that 3/4 of elections fail to provide voters with a choice of candidates for the judgeship. So basically, once you're in office, even though you're not appointed for life. You are subject to an election every 4 years, every 6 years, every 2 years, depending on the state. 3/4 of the time, you're not going to have somebody running against that judge. So that judge wins automatically, right? And again, there's a question whether that's good or that's bad. I mean, that's more of a political question, but it also kind of raises some pretty big issues, right? Especially when you consider maybe death penalty jurisdictions, right? Because those are very controversial. Also, judges engaging in misconduct, which we'll talk about a little bit later. Even if a judge engages in misconduct, most of the time, as long as they stay on the bench, they're not going to lose their seat. So judges can get away with a lot of stuff that other politicians just can't. So to reconcile the problems between the appointment-based system, which had upsides and downsides, and the election-based system, which also had its upsides and has its downsides. The state of Missouri in 1940 adopted a merit selection plan. It's called the Missouri Bar Plan. Under the Missouri Bar Plan, when a judicial vacancy arises, a bipartisan commission consisting of both lawyers and non-lawyers, so citizens, interview and evaluate candidates for judicial positions, and then either one, make a formal recommendation for appointment or non-appointment to the governor of the state, or they provide a number of recommendations, usually 3, from which the governor can choose. Okay? And then after the judge's initial term in office, they are subject to periodic retention elections. And in a retention election, the question presented before the voters is, should Judge Smith, Judge Jones, whomever, be retained in office? In order to keep your seat after your initial appointment, the judge must receive a majority of yes votes. So let's break this down because I find it funny. It's called the Missouri Bar Plan. So the Missouri Bar Plan only applies to basically appellate court judges and Supreme Court judges, Missouri Supreme Court and Missouri appellate court judges. The Missouri Bar Plan does not apply to county level judges, municipal judges, traditional state judges, trial judges. Instead, in Missouri, trial court judges are elected in partisan elections. But the higher you go up the food chain, then the Missouri Bar Plan kicks in, and then the bipartisan commission gets together, evaluates candidates for appointment, and then after the initial appointment, the voters get to decide should so-and-so be retained in office. Now, the problem is, generally speaking, our electorate is not that informed, or they're misinformed. And that's usually about big seats, right? That's usually like president and stuff like that. There's still just a lot of ignorance, not in an aggressive or mean way, but there's just a lot of ignorance in terms of what different people stand for, what like really important issues that need to be addressed, things along those lines. People just kind of see party, or they see one issue and that's how they vote. And that's for the highest position in the country. Imagine a appointed Court of Appeals judge for the state, right? No clue, right? Most people have no clue who the appeals court judges are. Most people have no clue who the Supreme Court judges of their state are. I mean, most people don't have any clue who the Supreme Court judges of the United States are, let alone their state. So when you get this election, and when I voted in Missouri elections, I would get, should Judge so-and-so be retained in office? And then you kind of have to like check your phone real quick to see who they are, which is upsetting, right? And I consider myself relatively well informed. I wasn't at the time. I was much younger, but generally speaking, people are just going to say yes. Because unless that judge has done something just atrocious, on like barbecued a puppy or something, like we're just going to say, yeah, keep him on the court. It's just easier. Because then they say, well, if I say no, what happens? Right? And most people don't understand that the Missouri Bar Plan, if the person gets thrown out, then the commission meets again and they make an appointment, or they make a recommendation to the governor for an appointment, something along those lines. And a lot of people have the misconception that if they say no and the judge gets thrown out, then that's just how it is. Like that judgeship just goes away, it disappears. So they're voting for the position, not necessarily the person. Right. And again, it's hard to have people informed of top elected officials, much less trial court judges who don't really have much political leaning, or even state appellate court judges or state Supreme Court judges who do carry significant power in determining what a state statute means and if a state statute is constitutional in that state. But most people outside of the legal community just don't care. So let's talk a second about diversity on the bench, right? So we looked at this when we looked at federal court judges. The dominant profile, if we were to take a snapshot of all the judges in the United States, right, at the state level, whether they are elected, whether they are appointed, etc., that snapshot would show us that the dominant profile of judges are white males, right? Usually of Protestant belief, which I mean, you can't see, but they're generally white males, Protestant belief. However, what you would also see is this has started to change. Even though it still skews very heavily white and male, minorities and women are starting to become more and more common on the bench. And this is especially true in states that use merit selection plans, right? So merit selection plan is a way to get somebody who a commission believes is qualified for a job into office. And then the voters just always vote to retain them because the voters don't care. But in jurisdictions where they are elected, they don't do nearly as well. Minorities and women don't do nearly as well. Now, there are issues of prejudice that come into play, right? They think, oh, only a man can do this job. And that's obviously simply not true at all. But there is that thought process that some people do engage in. That being said, if we kind of take it outside of the elected realm and we look at courts of last resort, right? What we see is that when we use a merit selection plan in courts of last resort, half of all minorities and women judges are on state courts of last resort. So this doesn't mean that half of all state courts of last resort judges are women. It just means that half of all women judges and minority judges that are judges sit on a court of last resort, right? And at least 1/4 of minority and women judges sit on lower courts. So if we think about just a very wide example, so if you look in your book, there are some states that are so heavily skewed white male that if you look at box 2.6.8 in your textbook, you see that there are some states that have 0.0 minority judges, right? So think about, let's see, Montana, New Hampshire, Maine. 0.6% is Kansas. Alabama has 7.4%. But then when you compare that to some place like Hawaii has 65.1%, right? So there is a lot of cultural and regional elements to the use of women and minorities in judges' roles, right? And if we look at females, so females, that was just minorities. Females, they don't do so well in Kansas, because in Kansas, only 8.2% of all judges, all state court judges, are female, right? Whereas if you compare that to someplace, and again, this is still not a great number, but if you compare that to Massachusetts, in Massachusetts, 34.2% of all state judges are female, right? So that kind of gives you the high and the low. So again, half of minority and women judges are going to sit on a court of last resort, and then a fourth are going to be really on the lower courts. So take a look at box 2.6.8 when you get a chance, and it will test some of your preconceived notions as to how states and how people in certain states act and how they vote. But it will also confirm some very true regional biases, prevailing racial bias, prevailing sexism, etc., that unfortunately permeates much of the United States and especially the criminal justice system. So regardless if you are appointed, elected in a partisan election, or elected in a nonpartisan election, judges must abide by the 5 canons of judicial conduct. Under these canons, a judge shall, 1, uphold the integrity and independence of the judiciary. Right, that's fairly broad. 2 kind of helps explain 1. 2, avoid impropriety and the appearance of impropriety in all activities. Right, so don't be shady, don't look shady, don't engage with shady people, right? Because you want to show that the judiciary is independent, it has integrity, that people can trust what judges say and do. They must perform the duties of the office fairly, impartially, and diligently. Now, again, there are some questions that get brought up here, whether judges are truly impartial. It's hard to say. I mean, are any of us ever actually impartial? Right? Because you go in, you see somebody, you assume things about them immediately. And judges are human, and so they do that too. But they're supposed to be impartial, they're supposed to be fair, and they have to be diligent in their duties. Canon number 4, they engage in extrajudicial activities that are consistent with the obligations of judicial office. Right, so this is, you engage in community service projects, you engage with the community to show that, 1, judges are people, they're accessible, and you can build that trust and that rapport with the community, and that you are engaging in activities that are consistent with the rest of these canons, right? That make sure that you're avoiding impropriety, that you are upholding the integrity of the system. So again, we strongly encourage judges not just to sit on the bench, but to go out into the community, perform community service, do good acts that builds our faith in the judiciary. And the number 5, which is really just a wow one, is refrain from political activity. So in partisan election states, the canons of judicial conduct apply as well. In these states, judges can engage in political activity insofar as their election. Once a judge is elected, they are not supposed to endorse candidates from a party. There's even been arguments that they shouldn't even be able to donate money to candidates from a specific party. And the rationale, I mean, it's just, it Obviously, it looks bad. It doesn't look like it's impartial, anything along those lines. They're also not supposed to engage in political activity insofar as their elections are concerned. And elections, again, become a big problem here, because if we're engaging in activity that's inherently political, let's say I am a judge and maybe I'm not following all the canons of judicial conduct, so I'm not being fair and impartial, but I have two people scheduled for a bench trial before me, or at least they're sentencing before me. Let's go with that. Sentencing before me. Both of them was a first DUI offense. One of them is John Smith. The other, Jane Doe. John Smith donated $5,000 to my campaign last year. Jane Doe donated $300 to the other campaign. Now, theoretically, I'm supposed to treat them the same. But am I? Because when I run for re-election, if I put this guy in jail, he's not going to be able to give me $5,000. Or if I rake him over the coals, he's not going to want to give me another $5,000. Right? So theoretically, I should recuse myself. But again, in elections, if most judges run unopposed, you'd have to recuse yourself in every case, and that just wouldn't make sense. Right? So this is where the true test comes into play: is do you treat John Smith the same as Jane Doe? Right? Because if John Smith, for their first offense, everything's the same. If John Smith gets probation and Jane Doe gets 60 days in jail, well, you may have violated a canon of judicial conduct. If you violate a canon of judicial conduct, you are subject to discipline by the State Bar Association and by the court of last resort of that state. Now, the ABA, the American Bar Association, has their own 4 general canons of conduct, right? So this is if you belong to the ABA, which everyone does. I do. It's just kind of like the thing. Therefore, canons say that a judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and avoid impropriety and the appearance of impropriety. So basically what they just did is they took number 1 and number 2 from the established canons of judicial conduct and combined them. Right? They're supposed to perform the duties of judicial office impartially, competently, and diligently. So again, it's very much a reflection of the prevailing law. 3, the judges shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict with the obligations of judicial office. Now, this is a really important one, right? So if you are an administrative law judge dealing with issues that involve the Securities and Exchange Commission, that involve like the trade of goods and whatnot, a lot of times the best thing that you can do is sell all of your stock, or at least put it into a blind trust. So you don't know what stock you have, you don't know how much stock you have, etc. Because if I own 20,000 shares at, I don't know, $10 a share, right? So what? That's $200,000 worth of stock in company X, and company X comes before me because they're being sued by company Y. Well, there's a big conflict of interest there, right? Because I have a side. Because if my side loses, if I make a ruling against company X, their stock prices drop, and thus my portfolio drops, and it hurts me financially. So your goal is to minimize the risk. You don't have to eliminate it, right? So it's to minimize it, not eliminate it. But it should be done in such a way that you can still hold stock, but you should be the one making decisions to buy and sell. You should not know what companies you have at any given time, things along those lines. That should be left up to a blind trust or an independent broker who does not disclose that information to you. So that way you can still play in the stock market, but you've minimized the risk of becoming partial to one side or the other. And number 4 says they're not to engage in political or campaign activity that is inconsistent with the independence, integrity, or impartiality of the judiciary. Right. So again, this is, we don't want you taking money and then treating people differently, but we also don't want you endorsing certain people. We don't want you endorsing certain politicians. We don't want you giving money to politicians, even if they're from your party. Now, you can argue that's a violation of the First Amendment, free speech, but it's also a consequence of the job. Like, you didn't have to choose to become a judge. You chose to become a judge, right? So you lose, just like if you choose to commit a crime, you lose certain freedoms. So that's why usually you don't see judges coming out during election years and then endorsing a candidate, right, for president, for state legislature, for whatever, because generally they're not allowed to. Right? Not that they don't have their own opinions, not that they don't want to support people from their own party. It's just they, under the canons of judicial conduct, both the ABA canons, which a lot of the states have adopted, and then the more formal traditional canons that we just covered, the 5, judges are very limited on what they can do politically. So what happens if we have a judge who violates the canons of judicial conduct or the canons of judicial ethics? Any judge who violates them are subject to discipline. So, for instance, if a judge does not recuse themselves when they have a conflict of interest, right? So they, let's say, before them, their best friend gets charged with burglary. Their best friend, their personal best friend, gets charged with burglary. And once you know it, in the lottery, they get the case. The judge walks into court, sees that his best friend is the defendant, and does not recuse himself or herself or theirself. That's a conflict of interest, right? Because that person's your best friend. Are you really going to throw your best friend in prison? Like, are you really going to be fair and impartial, or do you already have an allegiance one way or another? So in that case, they have a conflict of interest. And when they have a conflict of interest, if they do not what's called recuse themselves, or basically say, I'm not going to hear this case, they may be either privately or publicly sanctioned by a state's judicial conduct commission or the state's court of last resort. Now, generally speaking, most times when a judge is reprimanded, it's done in private. So the electorate, anybody in the bar, like, nobody knows about it except the Judicial Conduct Commission or the state court of last resort. They're the only ones that know about it. If it's done publicly, they publish like a public letter where they admonish the person in public about what they did. Now, this theoretically can jeopardize their chances of reelection or reappointment, but like we said, in most cases, it really doesn't. And when we think about how many judges there are in the country and what all they are responsible for, think about something like this. Each year, approximately only 100 judges are publicly sanctioned, right? So the vast majority are privately sanctioned. And since it's private, we don't have a full record of how many judges are privately sanctioned. But only 100 in any given year are publicly sanctioned. Now, it's part of the reason is because if we decide to give somebody a public sanction, or if the charges are against them are severe enough to warrant removing the judge from office, or some kind of public sanction, including a public warning, a public reprimand, a public admonishment, a public censure, a fine, and or suspension without pay, then formal proceedings have to take place. So the judge gets due process rights, and the judge can hire an attorney, and they go through that whole process as litigating whether or not this judge violated the rules and the canons of judicial ethics and judicial conduct. Right? So really, anytime something can be public or anytime they can be removed from office, they are entitled to these due process requirements. If, however, these the issue is just going to warrant and is not severe enough to warrant anything like that, but it's something, but it's not like nothing. Then in that case, they will get a private sanction and they have no due process. And the rationale is nobody knows about the private sanction except for that judge and that issuing body. And none of them talk about it, right? I mean, the judge theoretically could talk about it, but why would they? And the sanctioning body generally can't. So again, private sanctions, that's what we're going to see most of the time. But keep in mind, public sanctions or anything that can remove a judge from the bench, they get a formal process, a formal hearing. They get at least the minimum protections of due process. That being said, next class, we are going to take a look at pre-arrest procedures. So we'll be moving into section 3, looking at the adjudication process